Professor Tribe, when I read the 5th and 14th Amendments of the Constitution being cited, we desperately reach out to you for your interpretation of what you read in this motion today that, unlike any I've ever seen, tries to just wipe out the very existence of a special grand jury.
Well, it was indeed a remarkable document. I was a little worried at first. I thought it was going to be, someone said, a 485-pound document. It turned out to be 485 pages. Most of them were just filler. It was very easy and quick to read, over dinner, in fact. It doesn't say much of anything. It makes bizarre claims. It says that Judge McBurney was really unfair, but doesn't show anything about his supposed unfairness. On the contrary, he ruled quite often against things that Fani Willis wanted to do. It asked to have Fani Willis and her whole office removed because they were illegal or unfair. But that effort was already made by the fake electors, and they were quickly turned away by the Georgia courts. There's really nothing here. It's just air. It's obviously designed to delay, to confuse. You could say that it shows desperation, except I can't believe that the lawyers expect anything other than a slapdown, but undoubtedly instructed by their client to delay. That's his go-to strategy. They did their best. I feel sorry for them. There's no there. And in fact, the patience of the judicial system has got to be wearing thin. I mean, this is his technique everywhere. Throw everything against the wall, hope something will stick. Here, for example, he pulls out these doctrines about vagueness, which are basically designed to limit the ability of laws to trap ordinary citizens with confusing instructions. They're not really designed to insist that the laws structuring the criminal justice system meet some special standard of clarity and predictability. These laws setting up the special grand jury are no vaguer than any others. It's a standard technique. It's not often used, but there's nothing wrong with it. And the main point is it's not a trial. It's simply part of the investigation. The special grand jury is an investigatory body. That's why it cannot return indictments. He's just jumping the gun, predicting that somehow he'll be able to succeed in getting useful delay, but I don't think he's going to get much out of it.
So they specifically go after the district attorney, try to have her removed. They specifically say that the grand jurors were prejudiced when all of their interviews actually revealed that they were not. They specifically attacked the judge in the case. And then, for the biggest swing of the bat in the whole thing, it's against the Georgia legislature in the 1970s when they wrote this law, when they say that the law itself that creates special grand juries, that law is unconstitutional and creates a process that lacks due process and fundamental fairness, that it's actually in the very design of any and all versions of special grand juries created since the 1970s by that law.
Right. He's basically arguing against the idea of having special grand juries. There's nothing in the state constitution of Georgia or in the U.S. Constitution that gives him any support. In fact, the one right in the U.S. Bill of Rights that has not been held binding on the states is the right to have a grand jury before any charge is brought involving a felony in a federal court. But you don't even have a right to a grand jury, let alone one that meets some made-up standard that would satisfy Donald Trump and his lawyers. So the whole thing is disgracefully made up out of whole cloth, and eventually the courts are going to lose their patience, unlike what they pulled with the foolish introduction of the witness that kind of revealed their strategy in Manhattan. The defense attorneys here didn't reveal anything other than that Fani Willis doesn't have much to worry about in terms of the skill of her opposition.